Good evening, everybody. I'm Naomi Brickle. I'm the project director of Supported Decision Making New York, and we're a project right now funded by OPWDD and housed at Hunter College. More importantly, I'm the mom of 6 children, 3 of whom had IEPs or have. I currently have 1 child still left in school who has an IEP. And so I have developed an expertise on post-secondary transition through my experience, both personal and professional in the field. In my previous role, I worked at Westchester Institute for Human Development, where I oversaw something called our Community Support Network, where we did a lot of work with schools, agencies, and families navigating disability service systems and creating more community and inclusive program development for people with intellectual and developmental disabilities, especially in the stage of transition. Again, I bring my expertise that's both personal and professional, and even to the topic at hand tonight. I currently, my third child is a daughter with autism, who is actually in the process of creating her own supported decision-making agreement. So when I talk to you tonight, I will be sharing really firsthand experience, and my goal is to really try to approach the topic from the perspective of a parent and a person who is confronted with post-secondary transition, getting ready for your child to age out of school and become an adult, and some of the considerations that you're faced with. I want to start by, well, with the question for all of you, and you don't need to put it in the chat, but my question is this: how many of you are here tonight because you've been told or are trying to make a decision about guardianship? As a mom who, who had several kids finish high school, I do know that in particular for my daughter with an intellectual and developmental disability, that the directive, for lack of a better word, from the school and from professionals supporting me throughout her life was, she's 18, you'll have to get guardianship. As a parent, it just seemed that that was the right thing to do because that's what the school told me to do. And as professionals, I was under the impression that they knew better than me about what's next in life and what were important considerations to prepare my daughter for adulthood. So I really want to come at it with that because I do believe most of us who have kids with who will require, especially kids who will require OPWD services, this is just the script we've heard. This is the default recommendation by schools, and I really want to preempt it right from the beginning by sharing just an anecdote an anecdotal experience I recently had in speaking with a very well-informed, intelligent school district special education administrator. She took the time to come and hear about my project. This is somebody who's very much recognized as a leader in her field and has done some really innovative program design. And she listened to me speak on what I'm about to talk to you about tonight and said, I had no idea about any of this. I've never heard of it. I was always told that families needed to get guardianship, and that's what I've told them. Thank you so much. I really want to spread the news to all of the other educators in the field, so that they understand that this is not that guardianship is not just simply the default for these kids. So I want to put that out there because I've had friends and I've had families and family friends who've come to me, and when I've talked about my work in this project, it's almost always a default for them to say, oh yeah, but that's not for my child because the school told us, or the doctor told us, or somebody told us to get guardianship. And I just want to drive this home right now that the doctors are not lawyers, educators are not lawyers, and that none of these people have an expertise to be recommending guardianship. So I really want you to become educated yourself so that you can make an informed decision rather than a decision that's just based on a default advice from other professionals. So first of all, let's start with just a little bit of context. I want to just talk about what the differences are between guardianship and supported decision making, because I did not understand this. For me, when I first started hearing language about supported decision making, I kind of saw it as almost like a guardianship light. And I want to start at the very onset by dispelling that misperception for any of you who might have it, because it took me a long time to get to this understanding, and I want to nip it before so that you don't have to. But it's really quite simple. Guardianship is simply a legal process where the rights to make decisions about about a person's life are taken from one person and granted to another. I'm not going to get into the motives or right in this. I'm just simply black and white explanation. It's a legal process by where the rights to make decisions about a person's life are taken from that person and granted to another. Whereas supported decision making is actually a series of relationships, supports, agreements. It can all different from informal to formalized agreements about support so that an individual can maintain that decision-making authority about their life. Okay, so whereas guardianship, the decision-making authority is given to somebody else. In supported decision-making, the individual actually does retain their legal capacity, their legal right to make decisions about their lives. But a structure of support is built around them so that they can enjoy that right more meaningfully and safely, and hopefully safely. So let's get a little bit into the context and whys, because while guardianship is a very restrictive, does actually take a person's full rights from them, and especially here in New York, 17A guardianship, which is the type of guardianship that people with intellectual and disabilities, when a parent goes to get guardianship over their child at 18, in 99% of cases, that guardianship is something called 17A guardianship. And in the next slide, I'm going to show there's actually two types of guardianship in New York State, 17A and 81. And when we're talking about guardianship in the context of our children tonight, we're really talking about 17A guardianship. And 17A guardianship is something called plenary, which means it's it's all or nothing guardianship. It's guardianship of the entire person and that person's property. In some cases, 17A guardianship may be granted as either person or property, but in the great majority of cases, 17A guardianship is all or nothing guardianship. It is guardianship of the person, plenary guardianship of the person and their property, and all decisions about both. So why would we have created this? Why would we create something that would be such a drastic stripping of a person's rights? Well, the context of guardianship is actually, it came with good intent. Guardianship came about at the time where, well, let me just even go back first before I even share this to say that guardianship, 17A guardianship, New York is one of only a few states that actually has these two types of guardianship, and 17A guardianship is perhaps the most or one of the most restrictive forms of guardianship in our entire country. Okay, so in most other states, when a family goes to get guardianship over their individual, it's a very different type of guardianship. It's more similar in many cases to our Article 81 guardianship. And again, I'm going to show those side by side so you can see the differences and get the context. But I just want you to understand that we do have two, and our 17A guardianship is the most restrictive form of guardianship, probably one of the most restrictive in the country. So why would we have done this? New York's really progressive, right? We really believe in human rights. We actually have one of the most generous and progressive developmental disabilities service systems also in the country. Now, a lot of us who have heard about OPWDD or experienced OPWDD services, we may feel like, oh, it's a frustrating system. It's difficult to navigate, and that's true. And the hoops are big, and the crossing I's and dotting T's can often be complicated. But New York has one of the most generous developmental disability service systems in the country. So why would a system that's so generous also be so restrictive? Well, part of it has to do with New York was also one of the first states to actually deinstitute. We were very much had leadership in the deinstitutionalization when we first started deinstitutionalizing individuals coming out of institutions. And when that happened, families were really looking for ways to protect their children as they transitioned to live in the community. They were trying to protect them from exploitation. So the original guardianship law, this original 17A guardianship law, was actually came with good intent. It was about protection. But here we are 30 years later or more, and it was really what was made to protect individuals and from not being exploited, or to be able to have people served by third parties and provide consent. Um, it's really old fashioned now, 30 years later, and it's overly restrictive. So while it came about from very strong advocacy, it's become outdated in how restrictive it is. Another reason we've gotten here is what I've already spoken about, this pipeline from special education into guardianship. I don't know how many of you have children of transition age, but many of us who have kids, who've had kids with IEPs, who are going to need lifelong supports. A lot of us were presented with a checklist. In fact, I'm sure Include had this checklist. I know in my previous job, we shared this checklist, a checklist of what families need to do as they get ready for transition. And right front and center on that checklist was guardianship. So a lot of the reason why we just go for such a default into guardianship has to do with our history. And um, and so where does supported decision making come from? Supported decision making has really come out of disability rights and a shift from a social model, from a medical model of disability, where disability is perceived as something wrong, to a social model of disability where disability is perceived as a form of diversity, and where people with disabilities are just another part of the fabric of our culture. Supported decision making is not specific to New York. It's not something that's unique to here, and it's not something that's informal. It's really part of a much greater international, worldwide movement connected with the International Declaration, the Universal Declaration of Human Rights, which all of the countries in the world agreed to and participated in the development of after World War II, where really every country in the world came together and came up with these core rights of what it means, rights that we should all enjoy as being human. So supported decision making, and then it really comes from this right of the Universal Declaration of Human Rights. And specifically in 2006, a treaty at the UN was called the Convention on the Rights of People with Disabilities. And that CRPD, as it's often called, was really led by leadership, US leadership, but it was really about making more specific the rights of people with disabilities, so that they could enjoy their human rights. So I want to go just a little bit into, as I mentioned, guardianship comparison. So I'm not going to spend a lot of time on this, but I want to just make a couple of points to you. In New York, as I said, there are two types of guardianship, and it's the guardianship on the left side of the table, which is the type of guardianship that we're talking about when we're talking about our kids and getting guardianship for our young adults with intellectual and developmental disabilities. So what makes these different is really the rights that go into the two types of guardianship. Article 17A guardianship, an individual who's being considered for that goes to the family would go to a surrogate court. Whereas for Article 81 guardianship, which is guardianship in other cases, such as with maybe somebody had a traumatic brain injury and maybe the family wanted to help that person with their finances and might get guardianship, a specific targeted guardianship. That would be Article 81 guardianship. Under Article 81 guardianship, the individual in question has a right to an attorney. They have a right to be notified that guardianship is being considered and to see that petition for their guardianship. A person who's who's being considered for Article 81 guardianship actually has a right to be present at the hearing. None of these are true for an individual with an intellectual and developmental disability whose family and or other is petitioning for guardianship. As I mentioned earlier, Article 17A guardianship is all or nothing guardianship, whereas Article 81 guardianship is targeted and specific to certain areas, and they can be tailored to a person's capacity in those areas. There is no accounting required for Article 17A guardianship, which actually creates a legal limbo when a guardian might pass away. That once an individual is put under guardianship, there's no exit unless that individual goes back to the court and can prove that they no longer need to be under guardianship. Whereas in Article 81 guardianship, it's actually the onus of proving whether a person needs to be under guardianship is actually on the person who's fighting to keep a guardianship. So whereas in 17A, the individual themselves has to prove that they no longer need it, in Article 81 guardianship, that person has a right to have their guardianship terminated unless the other party can prove that they still need to be under it. So really, well, the other big key point is that Article 17A guardianship, you do not even need an attorney to get. A family or somebody in relationship to the individual can actually go to the court without an attorney and petition the judge for Article 17A guardianship. So it's easy, it's simple, it's permanent, and it does not come with rights for the individual. Really, really important. So a lot of us are told by the schools or by doctors or by people in our lives that know better, that we need to put these guardianship in place in order to protect our individual. Well, there are actually other alternatives that can be used. I'm not an attorney, so I'm not going to go into detail explaining each of these, but on this slide are just some of the alternatives to guardianship for finances that might be considered. These include joint bank accounts, power of attorney, an ABLE account, perhaps a supplemental needs trust or a pooled trust, or a representative payee. There's also alternatives to guardianship for healthcare. There's HIPAA releases, healthcare proxies, and other laws that actually, and regulations that actually protect the family when an individual is incapacitated. So there are actually alternatives in place. Another important thing to drive home is that while many of us are advised that guardianship can help us protect our individual, you still need to go, should if an individual, if our loved one was to actually go get themselves into trouble, somehow get into a financial arrangement that they weren't entitled to be in because they had a guardianship, in order to remedy that, you'd actually have to go to court and and have it play out in court. And that's not a simple process, and that's not an inexpensive process. Guardianship does not protect individuals from talking to the wrong people, from being exploited online, from things on the dark web, as we call. So there are still, while many of us are led to believe that guardianship will protect our individuals, it is not a life preserver for our kids. In many ways, after what I've learned about supported decision making and what I've seen in our process and experience from families, in many ways, supported decision making, because of the process that the individual actually goes through, the learning process that they go through in our facilitation process, um, they're actually gain skills to protect themselves in ways that we may not even think about in guardianship. So when a person creates a supported decision-making agreement, they need to think about the areas of their life where they want or need support, and think of the people who can support them. And all of that gets documented, and it's the individual themselves who is leading the conversations, well, actually participate in the conversations. The facilitator who works with them leads the conversations, but helps the individual understand that in big areas of their lives, where support might be necessary, they can actually choose people and specify the actual types of support that can help them protect themselves. So I mentioned the Convention on the Rights of People with Disability, which comes out of the Universal Declaration of Human Rights after World War II. And I want to just draw your attention to this language, which is really about the right to legal capacity, that all of us as humans have a right to our inherent dignity, our individual autonomy, and a freedom to make our own choices. In the CRPD, the language about the right to make decisions about your lives is very strong. And this actual language about support for making those decisions is written into it as well. So while the Universal Declaration of Human Rights recognizes a person's legal capacity, a person's right to make decisions for themselves, the CRPD, in being solely targeted around people with disabilities, expands that, and also suggests that individuals not only are entitled and have a right to make decisions about their lives, but for people with disabilities, they are entitled to support to maintain that legal capacity and to make those decisions. So I want to ask you a question, because I don't know that I've done a really great job of driving home the human rights piece, but I think this example might be able to offer that for you. I want you to think about one noun that describes you. So for me, that noun I'm thinking that comes to mind is a mom. Okay, I want each of you to think of a noun, not an adjective, not nice, not smart, not a great skateboarder, not something describing you, but an actual noun that represents you. It could be a mom, it could be a student. Think of one. And now I want you to think about, how did you, with the exception of daughter or sister or brother or son, with the exception of those, almost any noun that I think any of you thought of required a lot of decisions on your part to get to that noun, to create that noun for yourself. And imagine if you didn't have the opportunity to make decisions about your life, to define who you actually have chosen to become. And for people who don't have the right to make decisions about their lives, they also don't have a right to define and to decide their own identity. So I'm going to tell you a little bit about our project. Supported decision making first became institutionalized as a project here in New York in 2016. It was funded by the New York State Developmental Disabilities Planning Council. And the goal was really to raise awareness about supported decision making. Another goal was to actually make a case for a supported decision making law in New York. And I'm happy to say that the project, after 5 years, was successful. Well, actually more like 7 years. It took around 7 years to really be successful because the legislation passed in 2022, recognizing supported decision-making agreements. What I want to drive home is that I mentioned earlier that supported decision-making is a part of a larger international movement, and that New York is not unique or doing something just neat and creative. But we are part of a larger movement, and we're actually leading that movement. New York has one of the largest projects and one of the most progressive processes and protocols and progressive law, in my estimation, in the entire world. So where have we come? Well, we've raised awareness. None of you would be here tonight if you hadn't heard something about supported decision making, if somehow you hadn't it hadn't come across your radar as a potential alternative to guardianship. And that really is due to the progressive, to the passionate of the team here at SDMNY that preceded me. Another really important thing is that they've accomplishment is the development of a facilitation process. New York's law, our supported decision-making agreement law, is unique in being we are the only place that does have a facilitation process built into our supported decision-making agreement law. And I'm going to talk to you a little bit about that in a few minutes. We also, in the initial few years of the project, not only did they make a case for legislation and have legislation passed, but they also convinced OPWDD to fund a pilot to create a sustainable infrastructure for supported decision-making in New York. And that is what we're currently doing here at SDMNY. In addition, we've educated courts. More and more judges are now recommending supported decision-making as an alternative to guardianship. And in fact, they're required to. Before granting guardianship, a judge has to consider if there's a less restrictive alternative. And now that, especially now in light of our new legislation, many more judges are considering supported decision-making agreements as a legally recognizable, less restrictive alternative to guardianship. So it's important for you to know about it because judges are knowing about it. And I know that there's several surrogate judges across New York State, including the surrogate judge in Manhattan, including the surrogate judge in Westchester, and several others. I happen to be in Westchester, and so I'm familiar directly with the decisions that are happening there. More and more judges are recommending that families consider supported decision-making before they're considering guardianship. So let's talk a little bit about our Article 82 which is the Supported Decision-Making Act. So it was signed in July of 2022. And I wanted to share this because this is some of the basic human rights language that's right up front in the language of the purpose and findings. The language I really want to draw your attention to is that language around outdated beliefs. We are living in a time where most of our young adults, most of our children in their transition years have been educated in inclusive settings or had at least access to inclusive opportunities. Very, very different from even a generation or 2 generations ago, from even 15 years ago. Our special ed system has evolved significantly. And individuals and families whose kids have been educated in more inclusive settings are not quite as quick to say, I want my kid in a group home. I know personally as a mom, that is not the goal for my own child. I really have worked to help create opportunities for her to live and work in the community, to engage with her friends. I'm proud to say she attended an inclusive college program. She utilizes self-directed services. She has a job. This is very different from kids who graduated school 20 years ago or exiting school 20 years ago and transitioning into day hab programs, sheltered workshops, and certified residential placements. And supported decision-making is part of this new time. So just some key points about our law here in New York. As I mentioned, New York's law is unique to any other legislation in the country because of its facilitation process, which I consider a built-in accommodation, so that when individuals create a supported decision-making agreement, they not only sign a piece of paper that lets them retain their rights, but they also, their signature and the facilitator's signature on the actual final agreement represents a process that that individual went through that indicates that they participated, they were able to communicate their wants and preferences, that they chose areas for support, that they chose the people that they wanted support, that they chose the type of support. So the signatures on the supported decision-making agreement do represent a process that not only enables the individual to retain their rights, but to enjoy those rights more meaningfully and safely. So our supported decision-making in New York, first of all, recognizes supported decision-making, our law recognizes supported decision-making, both informal and with a formal supported decision-making agreement as a less restrictive, legally less restrictive alternative that the court must consider before considering guardianship. The law also prevents third parties from discriminating against an individual who's created a supported decision-making agreement. So in other words, if an individual was to go to the doctor and the doctor just decided, oh, I'm not sure if this person has capacity, a doctor can't refuse to see a patient because they don't believe they have the consent, to have the capacity to provide consent. That doctor, if the individual has a supported decision-making agreement, which includes healthcare, and they're utilizing that agreement as it's according to its terms, that doctor is actually required to accept that individual as a patient, even if without guardianship. In the same way, third parties are required to enter into contracts with that individual should they be, and they can insist that they show them the agreement, that they show them and that they attest that they are using their agreement according to its terms. So in other words, if a person wanted to enter into a contract for, let's say, a landlord for rent, and a landlord might say, I don't want to enter into a contract with this person because they have a disability and I don't think that they have the capacity to enter into a contract. That person can actually show them their agreement. They can show them the terms of the agreement, that they have a person that's supporting them with these types of decisions, and that third party will be required to accept that person and accept their relationship. The new law also incentivizes people to choose supported decision making because it's a legitimate process. Uh, and again, as I brought up already, our law is the only one that requires a facilitation process to ensure that the individual entering into the agreement actually understands what they're signing. So as I mentioned already, supported decision-making can be formal, it can be informal, it can be as informal as the supported decision-making we use every single day. None of us goes out and buys a car without calling a friend, maybe checking with our dad, or looking on Google for, doing some research on Google. All of that kind of support, all of those different ways we get are ways that we get support to make big decisions in our lives. So there's all different types of supported decision making, from informal to formal, and we all use it every day. So let's talk a little bit about our process, because our process is the process that is approved according to the new law. That is the process that's approved by OPWDD. So in our process, individuals who participate, the individuals with intellectual and developmental disabilities who want to create their own agreements, they are referred to as decision makers. Oh, sorry. Decision makers retain their autonomy and their civil rights, and they choose the decisions that they want help with, as well as the people who they want to support them in those areas. A decision maker and their supporters work with our facilitators, our trained facilitators, to create a supported decision-making agreement. And that supported decision-making agreement details the types of support that the individual wants, or their preferences for support, as well as the people and the way they want to be supported. Important part of our process is that it is voluntary. So this has almost created a bit of a complicating factor, in the fact that when a family wants to petition for guardianship, it's the family that goes and creates, the petition, that does the petition, that goes to the court with their documentation. In order to create a supported decision-making agreement, the individual actually has to participate. They have to be a willing participant, and they have to be willing and able to express their preferences in their agreement. Our facilitators are trained to work with individuals to provide accommodations, but in the end, if an individual is not willing to participate in the process, then the agreement is not developed. We use a three-phase process, and the individuals in our process, as I mentioned, there are different roles. We have the role of the decision maker, the role of their chosen supporters. The facilitators are the people who work with the individuals to create their agreement, and with their supporters to negotiate that agreement together. And then our facilitators all have mentors to ensure the quality of our process. We work in a three-phase process. Phase one is really focused solely, but it's a series of meetings between the facilitator and the decision maker, where they talk about decision making. They go through some of the theoretical framework of decision making and social network theory, so that when the individual does choose areas, they've chosen them with thought. They've chosen the types of support they might want. They've gone through processes that they're making these decisions about who to include, what areas, and the types of support they want in each of those areas. We have real process to take them through so that their decisions about those are informed. Phase two is about educating the person's chosen supporters, where we talk with them about our process. We educate them about the role of a supporter, which is different from the role of a parent. It's different from the role of a substitute decision maker, where it's more about supporting that individual in their own autonomy and their own decision making. Where the supporters are people who are really, their role is to help the individual in their own decisions, for them to support them as they make their own decisions. And phase three is really where everybody comes back together, and those terms of that agreement are fleshed out, discussed, so that in the end, everybody before they sign is an agreement about what they are agreeing to when they sign that agreement. So in addition to a signed contract, which is represents the agreement between the individual and their supporters for the areas of support and the types of support. Another product of our facilitation is that this supported decision-making agreement is actually a fluid document. It's something that's intended to change over time. Our document is designed so that it can be changed over time, where people can be added or areas for decision making can be added as the person and things that are as their life changes and the things that they're making decisions about and the people in their life all change. One of the big things we found anecdotally in our process, and we're now seeing with a research project that we just completed, is that there's a real recognition of enhanced autonomy of the individual and their own confidence in their decision-making capacity. So we really see growth in the decision maker as they go through our process. And even most important is, so do the families, where families are have been really recognized that through participation in this process, they really begin to see the growth in their decision maker, as well as they gain strategies to continue to support that growth. So let me tell you a little bit about our grant so that you understand what we're doing and how to access what we can offer you. As I mentioned already, we are funded by OPWDD under an implementation grant to develop a service system for New York State. And we're doing that with three major components. One of the big pieces is we're in the process of creating a statewide network of facilitation partners. So we're partnering with agencies as well as self-direction brokers. We're even partnering with lawyers to ensure that no matter what piece or service an individual is using to access OPW services, that they can access this service. So we've been very careful and thoughtful about choosing partners so that no matter where an individual accesses OPW services, they will have access to our services as well. Another big piece of the project is to develop a technical assistance center. So we have staff who are becoming expert and who can provide mentorship to our trained facilitators across the state, but also educate stakeholders. In addition, a big goal of the project is to create a system that ensures high quality and credible agreements. So we have invested a big part of this project into an evaluation to help us ensure that the processes and protocols that we are developing as we create this system for service delivery work well. And finally, we are developing, the infrastructure. So one of the big projects we've worked on over the past several months is a whole IT infrastructure, so that all of the process will exist in a platform so that we can really monitor the process and that agreements that are created are stored so that people have access to the work that they've done, even after they sign their agreement, and then can go back and update their agreements with support if they would like to. Some of our accomplishments thus far is our staffing. We're fully staffed. We've developed outreach and training calendars. We do a lot of sessions like this, but we also hold regular weekly information and sign-up sessions for individuals who wish to participate. We've also done a lot of work on our curriculum for training. As I mentioned, we've developed a IT infrastructure, and we're doing a lot of outreach and education of all stakeholders. As I mentioned, there's a real pipeline from special education into guardianship, and we're really looking at how to redirect people so that individuals can maintain their rights. Some of our big goals going forward are to continue to develop administrative processes so that the system works. We are doing a lot of work trying to fine tune our materials with the help of self-advocates who have been through our process, who are giving us feedback on how to make our materials and resources more effective. As I mentioned already, we continue to work on our evaluation and work closely with our evaluator. And also we continue, as much as it's an accomplishment, we also continue, it's a goal to continue to reach out to the field. So with that, I'm going to finish. I'm going to leave the slide up so that you can contact us. That QR code will take you to our events page. I have all the links on the right to follow us or access our website. I will say our website has amazing resources, including some Spanish resources, and also resources that are easy read, specifically created for people with disabilities. So that's that. And let's see. I don't know if somebody wants to read questions, or maybe I can just go through and see. See what the comments. So if you have questions, you can put them in the chat. Somebody asked, will the slides be shared? Yes. I sent them, and I believe they're being sent out to all of you. Oh, sorry, I see that was answered. Are there credentials or criteria to be on a supported decision-making team? Great question. No, the only requirement to be part of to be a supporter on an agreement is that you participate in the facilitation process, which simply means that you work with the facilitator so that they can ensure that you understand, you know, what your role is, what the role of a supporter is, what the law says about the role of a supporter. It's not a very involved process to work with our facilitator, but we just really want to ensure that people before signing agreements know what they're getting into. So there are no credentials or criteria to be a facilitator on the supported decision-making team. We are currently working with facilitators from agencies that we've developed contracts with. So we are currently only are working with trained facilitators who've gone through our training. We're actually in the middle of a training right now. And then those facilitators work under contract with us to provide facilitation services. We have, if there are people in the audience who are interested in talking about the development of an agreement like that, we do have a small pilot with independent support brokers who are being trained as facilitators. We probably won't have our next training until the summer or early fall, because as I said, we're in the middle of one now and we have a pretty big cadre. So that there is actually a credentialing process to become a facilitator, and you can reach out to me privately if you are interested in learning more about that. What is being done in the medical community? Great question. That is one of our deliverables, is to educate the medical community. I will tell you, it's a big nut to crack. It is, but we are making efforts. That will be one of our priorities. Our priorities in the first year were very much focused about developing our contracts and our partnerships so that people had access, and developing our infrastructure to be able to house it. But we're really, the outreach and education is going to be a big priority in year 2. If you have ideas about that, you have my contact information. I would greatly appreciate ideas for that. When I say which does that mean SDMNY facilitates the process of reaching these agreements? Susanna, in answer to your question about our process, yes, the SDMNY facilitation process is currently the process authorized by OPWDD to create legally recognizable agreements. So anybody can create an agreement, but in order to be recognized and meet the offer the protections of the new legislation, agreements do need to be authorized by OPWDD or need to be developed by facilitators who are authorized by OPWDD. And currently, it's the SDMNY is the authorizing facilitator, authorizes the facilitator. So that is what I mean when I say our process. Oh, I see that someone tried using the QR code. Thank you. I'm gonna put then well, if you actually, I don't need to because it's right on the slide, but I'll do it because then you can just cut and paste it. www. So I just posted, that's so strange. I'm sorry about the QR code. I'll have to figure out what happened there. It was working last week, but in any case, that I just put our website in the chat, and there's an events page also that I recommend you go to for more about our process and information sessions about our process. Our school districts being educated on this, that is also one of our priorities for this year. Thank you. As a mom of a son, where can I learn more about the nuts and bolts of supported decision making, such as the basic categories of decisions that will be covered? I would recommend on our events page, there are other information sessions. I didn't do a whole lot on our process, our 3-phase process, and those information sessions are held, I believe, every other week, and do have more information about the actual nuts and bolts of the facilitation process. The only other thing I want to add is that in addition, if you were to go to our website and you were to look for events to attend, information sessions are sessions that really provide information about the facilitation process. Sign-up sessions are specifically for individuals, potential decision makers, or DMs as we call them, who wish to sign up. And it is required that the individual participate in a sign-up session. Thank you for posting that. So that's it for me, unless there's any other questions. I don't know if I missed.
Yes, Naomi. Yep. In the Q&A portion, we have, are you able to see the question?
Yes, okay.
Okay.
So do I have to initiate the process? Hold on, let me bring this over. Or will my son's school transition coordinator help me? You should definitely contact us on our website. We are working with schools, we're trying to educate transition coordinators, but there are many, it's quite likely that if you go to your transition coordinator, they might say you need to get guardianship. I also see you're asking, your son is 17 and will turn 18 in December. Our process can be started while you're 17. An individual can't sign a contract until they're actually 18, the age of majority. So we do initiate the process. We do start our facilitation process with individuals while they're 17 so that they can be ready to sign the agreement when they're 18. But an individual who's under 18 cannot actually technically sign a legal contract. So the signing ceremony would be held in December after your son turned 18. Anything else? I guess not. So please contact us. All of the contact info is there. We have a general info line. And if there's no other questions, then I want to thank you guys all for your attention.
Great. Thank you so much. We would like to thank each and every one of you for joining us today, and we hope that you have learned useful information and gained the resources that support you and your child's growth and development. A special thanks to Naomi Brickell for tonight's very informative session. And again, if you have individual questions and want to speak to an educator, please call the Include NYC helpline, and the information would be in the chat. Thank you, everyone, and I wish you all a good evening.